SJC-11492, Marcia D. Bellerman and others, v. Fitchburg Gas and Electric Light Company.
Good morning.
Good morning. Attorney Barry Altman for the plaintiffs, Kathy Clark et al. And the putative class members. May it please the court, I'm going to spend 10 minutes of our allotted time on class certification. Attorney Deborah Phillips is going to spend 3 minutes on collateral estoppel, and we reserve 2 minutes for rebuttal. Your Honors, a class should have been certified in this case because there is similar injury and adequate representation. As in your Ian Acino case, all FG&E customers after the Hurricane Bob order in 1992 paid for a level of emergency preparedness which they did not receive. Instead, despite representations of preparedness and the non-disclosure of unpreparedness, they received a pervasively unfair, deceptive, and grossly deficient system/course of conduct of emergency preparedness, restoration, and communications that was the worst ever seen by the DPU, and it was called a debacle by the lower court at, I believe, page 29 of the summary judgment decision. And as a common adverse consequence under Hirschenau, all customers paid a price premium. In addition, they were unable to plan to cope with the outage, which in turn resulted in similar losses such as spoiled food, burst pipes, etc. And that's whether an individual member of the putative class was out 1 day, 2 days, 3 days, 4 days, or more. It's just a question of damages. In Salvis,
Is it a question of damages or causation? I mean, if my power is out for a day and it's restored, is it because the company was unprepared, or just because they were able to get to me first, or because the damage was to some central thing that was, I mean, isn't it a matter of causation here? I mean, some people may have suffered damages because of unpreparedness. Others may not have. Many others may not have.
I would say that they all did, and let me explain. In Salvis, this court ordered that a class of workers be certified based on a finding of a systemic scheme of wage abuse to which all employees were subject. So I think...
But somebody here could have lost power because a tree in their own property fell on the lines and knocked it down.
I'm glad you asked that. We're not complaining about the loss of power. That's not the issue. It could be, for example, if there was a way to do this, Your Honor, you could take a giant scissors and deliberately cut a cord, say, that would turn all the power off, and you'd laugh and whatever. We're not complaining about that. The law says even if you were to do that as a joke, cut the big cord that turned the power off, electric companies have, and this is where we get into, it's the key is restoration. They have the responsibility to restore in a timely and efficient manner.
So you're saying that they have that responsibility, and it's not a causation question if with respect to the people that lived, there's a particular neighborhood where the power came on in 1 or 2 days, and I'm not going to remember where, but let's assume that the notices were okay as to when it would happen, and it did in fact get turned on, and the 2 days was, in that circumstance, purely because of what nature had done. So is that causation? I mean, this is Justice Corey's question, but is that causation or just that they get $25 of damages?
The DPU found that there were systemic deficiencies. I think that the key is, and going back to Justice Corey's question, if there hadn't been the finding of systemic deficiencies in course of conduct, then every customer or putative class member would be on their own. They would bring their own case, just like in Salvis. But the minute there was a systemic scheme of wage abuse, that's what allowed the class action to be brought, as opposed to Crystal Salvis bringing her own claim and everybody else bringing their own claim.
So you're saying causation, in a certain sense, the cause of the loss of power to an individual household is irrelevant. It's the right to a reasonable period of restoration of power.
And see, that gets in, my brother,
It's the plan to restore power that was deficient.
and the actual implementation, including the communications. It was, if you've read the DPU report, it was everything. It was pervasive. Just like in Salvis, it was systemic. So that's why, again, in Salvis, if it hadn't been systemic, Crystal Salvis would have had to bring her own case. But the minute there was the showing that it was systemic, that allowed the class action. And I would say that
people were going to lose their power.
Absolutely.
That's God's will. That was
Absolutely.
a terrible ice storm. People are going to lose their power.
Correct.
Some people got it restored quite quickly, within a day or so. Others didn't. Now, the others who didn't, it may be that some of the systemic problems caused the restoration to be delayed, but those who got restored promptly or reasonably quickly in light of the disastrous nature of the storm, where's the causation there?
Well, let me talk about the causation there in part is communications. The key in an outage is being able to plan what to do, whether you're running a court, you're running a business, you're running a household. So beforehand, you got flyers that the lower court found to be or could be seen as misrepresentations. There were also, and Chapter 93A is about information. There were also omissions. The company didn't tell everybody. They weren't prepared for this, for this type of level of storm. That's why there was a debacle. So look at it from just the communication. So now they hear maybe that a storm's coming, but they've gotten the flyers. There's been no non-disclosure under Chapter 93A, which is all about information. So then on December, and again, this goes exactly to people who were only out. When we say only out for a couple of days, like last night, this morning, it was really cold. A couple of days, in our view, is still a big deal.
Yeah, but it could have been nature, as you say.
Right. It's going to be nature. It's going to be a hurricane. It's going to be a terrorist attack. It doesn't matter. That's a condition. But the company has a responsibility to restore power in an efficient and timely manner. And really important is letting people know what's happening so they can plan. So real quickly.
But let me just follow up on this. Somebody's driving up in the sky on a private plane, a Piper Cub, and during this storm, and somebody has power fortuitously. The only 10 people in this area have power. A guy is driving his private plane, and he crashes, and he knocks the power out in one of the houses that has electricity. You're saying that person who lost his electricity has been harmed. I take it you're saying this because the plan of the power company was inadequate to cover even those kinds of situations which are within, which they would have been required to repair, the power company would have been required to repair. Everybody is entitled to a certain repair under the plan, and to the extent that the plan for restoration has been stressed by a huge storm, that's really what this case is about. Their inadequacy to put everybody's power back on.
Are you saying if you lost your individual service?
Because a plane came in and you were, and the power company was working on the power lines someplace 5 miles down the road, and they didn't have an adequate number of trucks out there repairing it. Are you saying that that person whose power was severed because of an airplane falling out of the sky was entitled to damages?
No, what they're entitled to is efficient and timely restoration. And if they don't get it and it causes them damages. So just real quickly, the storm is a condition. We don't blame the storm. The storm hits, the company's not prepared. Beforehand, we say there were misrepresentations and non-disclosures. The storm hits. Now what happens? On December 11th, they say that they think there's a PSA that they think they're going to have the power on relatively quickly when they knew that they were looking at possibly outages for a week. Let me just go through the different PSAs. On December 12th, they said that FG&E personnel were working around the clock to restore power. No information about restoration. On December 13th, they said they were focusing on restoring major sub-transmission lines and will take days to restore power. What is
Mr.
days?
Altman, excuse me, I'm going to let you finish your thought, but your time is up.
And again, if you go through, there was no information that was specific to a community so people can plan, which in turn caused the resulting damages under Hirschenau.
Thank you, counsel.
May it please the court, Deborah Phillips. The fact of the matter is, the bottom line here, Fitchburg Gas and Electric had a fair hearing before the DPU. There's no need to relitigate issues that Judge Wilkins found to be the same there as the plaintiffs are asserting in this case.
Did he
What was
identify
the-
those issues?
Yes, we did identify those issues, and they're specifically in the record. Judge Wilkins set forth 6 specific DPU findings, and they're at 67, 30, and 31. They were put in the record below, specifically by me, actually, at the summary judgment hearing, at the oral argument. Judge Wilkins actually stopped me and said, "Where are you reading from?" And I know my brother cited in his brief to a place in the transcript where it appeared that the question the judge was asking was not being answered, but if you actually look a few pages earlier in the transcript at that site, you'll find this exchange with Judge Wilkins where we did place these specific findings
But what was the issue being decided by the DPU?
The issue being decided by the DPU was whether Fitchburg Gas and Electric violated its public service obligation to restore service in an efficient, effective, and timely manner. And that's in their decision it's our record number 140. And our issue is and has been since the complaint was filed whether Fitchburg Gas and Electric violated its public service obligations before and after Winter Storm 2008. That's cited in our brief.
You're saying that there was an adjudication by the DPU?
Oh, yes. This is a full adjudicatory hearing under Chapter 30A.
Is this on the issue of offensive use of issue
Yes,
preclusion?
I'm sorry, yes. I apologize. My brother had said that in the beginning. I was trying not to use up our time. Yes, absolutely. This is what we are asserting, and Judge Wilkins found that it was appropriate, and he did make some specific findings.
But there was no cross-examination at this hearing,
Oh,
was there?
yes, there was. There was cross-examination. They subpoenaed witnesses. There were 5 days of hearing. They made motions. They won motions. They submitted written and oral testimony. This was a full, fair hearing, just like before any other administrative agency. And this court has said that it will consider all the circumstances. They want to argue that we're shifting the burden. We are not shifting the burden here. They were a defendant defending themselves there. They are defending themselves here. The Attorney General was the proponent of change at the DPU hearing. And we, I guess, would be in that position in this case.
Who had the burden at the DPU hearing?
We assert that the Attorney General has the burden. It actually is not clearly articulated anywhere except in rate cases that the utility does have the burden. We assert that because they were being investigated, they were being looked at, so they were
It's like
sort
a
of the
prosecution.
Exactly. That's exactly the analogy. I see that my time is up, so I would just sum up by saying that they did have a full and fair adjudicatory hearing. Judge Wilkins did find the issues, and he did articulate at least 6 specific issues on those pages that I cited that we would like to continue to be settled for purposes going forward. So we're asking that be upheld.
I thought he deferred.
He deferred yes, absolutely. He deferred the rest of, but he did, if you look in his decision on the pages that I cited, which I think are around 35 and 36 of the summary judgment decision, he set forth specific findings.
That could be used offensively.
That could be used defensively. They included that FG&E was woefully unprepared for the storm, that they failed to comply with the directives of DPU Order 91-228, and that they misled customers, and multitude of other findings.
So then those would become, you would then argue, although those are factual findings from which one argues that there's been a violation of 93A.
Absolutely. Absolutely. Thank you.
May it please the Court, my name is Gavin Rooney. I'm appearing on behalf of Fitchburg Gas and Electric Light Company. The trial court did not abuse its discretion when it declined plaintiff's motion to certify a plaintiff class here. That properly applied the rule of causation and the statutory requirement in 93A to show causation of similar injury across a class before certifying a class.
But Mr. Altman I don't know if he argued this below, but he seems to be saying, at least now, that we don't look at we shouldn't be looking at causation as to what caused them to lose the power, but rather what caused the delay in restoring the power. There was supposed to be a plan in place for restoration, and take my example of an airplane falling out of the sky. How long would it normally take to restore power to that house? And how long would it normally, did it take as a result of an inadequate response by the utility company? That seems to be what he's arguing on appeal now.
That is a bit of a different position than was argued below, and I think the record below was clear that they were charging us with the loss of power also. But let me address the restoration point, because again, it goes to the causation issue. We had customers that were restored within 2 hours, and we had customers restored within 1 day, 2 days, 3 days.
80% of them were not restored for quite a bit longer than that.
85% were restored by Friday, the 19th of December. That is the day I'm sorry?
How many days
That's
is that?
7 days. But to put this into context, Your Honor, that is the day in which our neighboring utility to the south, National Grid, declared substantial restoration, 7 days. It was a terrible storm. Our neighboring utility to the north, which was Public Service New Hampshire, did not achieve substantial restoration until December 24th, 2 weeks later. So I think we can look to the performance of other utilities to have some sense of saying,
That goes
well,
to the merits.
well, I think it goes to the issue of causation, which is that to figure out if someone's power was out for too long, you have to get into the weeds of finding out, well, why is that the case?
But what about the idea of subclasses? I mean, one of them that Mr. Altman has mentioned in the brief was the deceptiveness about bills for December and January. I don't know the details of it, but there are identifiable, or there could be identifiable subclasses within this group that assert certain kinds of unfair or deceptive actions and certain kinds of damages that go together.
Well, on the issue of subclasses, first of all, Massachusetts Rule 23, unlike its federal counterpart, Federal Rule 23 does not have an authorization in it for subclasses.
93A is a different.
Yeah.
kettle of fish.
I understand that. I understand that. I think although Rule 23 is often looked to as a framework for thinking about 93A, as this court has said in its
Mr.
prior
Altman's
decision.
brief reminded me, I've approved of subclasses in some action.
And then secondly, with the issue of estimated bills, what the trial court found is that there was not a sufficient opportunity for argument of whether that was viable. There are various issues that come up in the estimated bills. Did the customer pay the bill, first of all? Second of all, was the customer in arrears on prior bills? And then third of all, no customer actually at the end of the day paid more than they should have, because even if there was an estimated bill, that's then, which is, by the way, authorized by DPU regulations to send out estimated bills when you can't do a hard meter read, there's a true-up in the next bill that comes out, so that the customer does not end up paying any more than they should pay after a 2-month billing cycle. And so I don't think there's a factual basis for such a subclass as the trial court, I submit, properly found.
Did the emergency restoration plan that the utility company had, did it contemplate that service trucks would be being used to restore power for causes totally unrelated to the storm, or totally unrelated to an emergency, to a particular emergency, that would also draw upon the resources of the company?
Well, the emergency response plan basically contemplated an all-out effort to restore after a major interruption. So all of the company's resources would be devoted to that. That would be the trucks that were on hand on a daily basis. That would be calling in outside contractors. That would be using various forms of mutual aid assistance to dial and coordinate with other utilities throughout the Northeast and even into the Midwest to get on loan crews from those utilities to help with the restoration effort here.
Wasn't there some evidence that the ERP did not account for storm of this type?
What the
this
DPU
severity, so that even the ERP that the company had was inadequate?
The DPU found that in its report that the company's ERP did not contemplate a storm of this magnitude. This was the largest storm ever seen in the history of the FG&E service territory, and that was a finding that the DPU did make in its decision. But it still doesn't necessarily bring us across the line into causation. And I think Justice Cordy's question at the outset of this argument was really the right one, which is how do we deal with the issue of causation class-wide? This
Well,
issue has been...
Doesn't it depend on whether or not there's a similar injury?
Yes, exactly so, a similar injury.
And isn't what's being said here is that the violation, there has to be a difference between a violation and the injury. And the violation here was that there was poor customer service, and that the injury was the inability to plan. And that the question then is, was that a similar injury suffered by enough people to certify a class?
Well, I think under this court's precedent, just saying across the board that 28,500 ratepayers, plus all their family members, dependents, employees, and tenants, had a supposed inability to plan is not enough to get a class certified under a similar injury theory. I can see that there might be examples out there where somebody had an inability to plan that created an actual injury, but there's no way to segregate that out without getting into the weeds of these individual claims to
Why?
find out the facts.
If
Well,
you
let's-
have enough evidence to show that the company sent out misinformation over a period of time, both before and after the event occurred, about its own planning, about its own capacity, about, its own level of preparedness, about a whole range of things, and then after the storm hit, about when restoration would take into account. Isn't that an overarching scheme of conduct that affected lots of people, and that there may be some people that weren't affected doesn't preclude the certification of a class?
Because the issue has to be relevant to the experience of an individual class member. Let me give Your Honor an example. There were 500 people that were served by the underground system in downtown Fitchburg. Because it's buried, it's largely insulated from the weather. They lost power for a couple hours because the transmission feed, due to no fault of my clients, went down for that period of time. Those people did not have an inability to plan at all. They probably woke up in the morning, their power was already back. Other customers had...
500 out of 28,000 something?
It's a layer of the onion. I can peel some more layers for
Well,
you.
but the question is, is there enough to certify a class?
Respectfully not, Your Honor. And the reason is, if we go into the other statements, let's look at the statement that came out on the 14th of December that said the restoration will take some days. And one of the criticisms by my adversary is that was not specific enough as to when the lights would be restored. On the day that press release issued, 5,000 people already had their power restored. Within 2 days of that time period, which qualify as days, I think, 10,000 people had their power restored. Another press release that's criticized in this case is one that issued on the evening of Tuesday, December the 16th. And that said primary circuit restoration will occur in Fitchburg by Thursday and the other towns by Friday or over the weekend. On the day that press release issued, 16,000 people had their power restored. And by those dates that were mentioned in the press release, you had over 20,000 people who had their power restored. So this is unlike the other cases this court has certified for class treatment, where the injury flowed directly out of the conduct without having to get into the weeds of what happened to individual people or members of the class. Take Aspinall, for example, where customers were paying an inflated price for Marlboro Light cigarettes as a result of deceptive advertising that the light cigarettes provided lower tar and nicotine. Everybody who bought the cigarette paid less than they should have, and moreover, they were running an increased risk of developing cancer that they thought they were avoiding because they were supposedly smoking something less harmful than a regular cigarette.
And Mr. Altman mentioned Salvis as being one where there's actually differences among employees. I mean, you've got an overarching abusive policy, but you've got different people affected differently, and maybe some not affected at all.
Well, I don't think that's really what this court held in Salvis. I think what this court held in Salvis is that there was a course of conduct. It was proven by substantial evidence, including an expert by the plaintiff to show injury to all class members. By the way, that's absent here. There is no such expert. And we're through discovery at the trial court level. There was substantial internal documents, including an internal audit showing that out of 128 stores nationwide, Walmart's own audit had concluded that wage abuse like this occurred at 127 of them. And the only real individual issue that was argued by Walmart in that case was whether, when people didn't take their breaks, whether they consented to that, whether they waived that. And what this court held in Salvis is that's an affirmative defense. It's not part of the plaintiff's prima facie case. And therefore, we can certify a class because individual defenses do not stand in the way of certifying classes. Our case is fundamentally different when we clearly have substantial damage here that was caused by Mother Nature. And the fundamental problem in trying to adjudicate claims here for spoiled food, staying at a hotel, taking your family out to dinner, or getting into the larger claims by the 4,000 businesses among our ratepayers, claims for loss of revenue, claims for food spoilage at supermarkets. We have one claim by a named plaintiff here for an $18,000 loss due to a burglary on the theory that the burglar alarm wasn't working because the power was out. In order to adjudicate those claims, we have to get into the weeds to figure out the causation. Why did those injuries occur? Did they occur because of Mother Nature, or did they occur due to some malfeasance or misfeasance by the company?
But does it? Why does it matter? Aren't we really talking about an emergency restoration plan that was supposed to be cause blind? Regardless of what the cause of the outage was, wasn't
because as the trial judge properly found, even with the most pristine, robust preparation, a lot of people are going to lose power for a long period of time.
And isn't
that is a fact.
But isn't that contemplated by the emergency restoration plan?
No, in an event like this, no plan out there could restore everybody within an hour. It's a physical impossibility. And,
but does it have to be an hour?
There is no standard. In fact, when I was in deposition of the plaintiff's experts, one of the questions I put to the expert was, well, from your perspective, sir, when should the last customer have been restored if everything was done right? There was no answer to the question that the plaintiff could give, and I therefore can't give Your Honor an answer to the question, even as the plaintiff puts together his case. There is no answer to the question.
I take it you would concede that there may be groups of people who might bring an action based on the similarities of their situations, right?
That is conceivable, and actually I would point this court to what's happened in other states, how other states have handled this. We've cited in the briefs the fact that no reported decision is ever certified a blackout class, and 5 other states have declined to do so, including New York, New Jersey, West Virginia, Louisiana, and Texas.
That was not under a statute like 93A in any of those instances.
But the issue of causation was at the core of each of those cases.
Well, the question is, what was the harm or what was the injury in those cases? And it was all the outage. It was just as the judge found here, it was the outage. But if you look at the injury differently, you might have a different result.
Well, I don't think the injury is really different than it was in these cases. And I argued the New Jersey case, and I had a very similar argument to this right now as to whether reset clocks, because everybody would have to reset their clock if the power went out, equals injury. And ultimately, in that case, it was held not to. And I don't think it really makes a difference that we're looking at the concept of injury under 93A as opposed to the laws of those states. But the way those states have handled this, and in New York in particular, and the court may remember there was a large blackout in New York City in 1977. Manhattan and the outer boroughs went dark for about a day or so. The New York courts refused to certify a class there for the same issues we're arguing today about causation and individual damages. But there were individual cases that went forward, and there were collateral estoppel findings that followed from those cases. Collateral estoppel from litigated trials, one of which was affirmed by the New York Court of Appeals, finding the utility to be negligent, and other ratepayers could take advantage of that and bring their own separate actions, and there will be separate actions here if the trial court's decision to not certify the class is affirmed. Let me just speak briefly about one area where we do believe that the court did make a mistake below, and the issue of collateral estoppel. Collateral estoppel under this court's precedent cannot be found unless findings are identified that are both identical and essential to the judgment. The judge below did not make those findings here. That alone means that they're error. And I think they're not essential because what the DPU was looking at was whether there was safe and reliable service within the meaning of Chapter 164. And of course, this matter is about deceptive conduct or unfair conduct within the meaning of 93A. More fundamentally, however, the proceedings at the DPU, while fair for the DPU perhaps, and we're not criticizing that, are not fair when they're transposed here. Hundreds of people testified, not subject to cross-examination.
Could have subpoenaed and cross-examined persons.
That would have been destructive to the process.
But you could have done it. You had the right to do it.
It would have been bad policy. It would have been destructive to the process of a public hearing.
But you chose not to do it.
Well, there were other, which we did not subpoena those people, that's true. There were other people who submitted written statements that were not even sworn, and those were considered by the DPU.
I take it there's a different motivation here as well.
Yes. There was a different motivation. The motivation is so different that we came in with 28 recommendations of self-improvement. That's the opposite of one would do in a tort suit.
But you were aware that this suit was pending.
We were aware the suit was pending. We were not on notice that the DPU findings would have collateral estoppel effect on this case. That was something that was argued later. And in this circumstance, I think it would be destructive to the DPU process to permit collateral estoppel to apply, because these storm investigations would then have to be defended as if they were 93A litigation.
Were you facing an enormous fine in this proceeding?
We were not facing a fine from the DPU under Chapter 164, although the statute's been later amended. The Attorney General was asking for findings under 93A and a fine there. The Attorney General had no authority legally to do that, and the DPU so found. So the claim was made, but it was a spurious claim as the DPU concluded.
The 6 areas that were mentioned in terms of, that Judge Wilkins identified,
Yes.
were those the subject of the cross-examination testimony, or were those part of the public hearing part, if you will?
It's hard to spin them apart. They were certainly, I would say, part of both. And one area that I think the plaintiffs especially like to focus on is the quality of our communications, as you've heard. That was a substantial component of the public hearings, both sworn and unsworn statements, not subject to cross-examination. Thank you, Your Honors.
Thank you, sir.
Mr. Alton,
If I might,
tell me what this trial would look like if you win on the class issue.
absolutely. How is this going to play out? At page 357 of the Salvis decision, it says, in the liability phase of this putative class action, it is not the representative plaintiff's burden to identify every specific instance in which a member of the plaintiff class has been injured or harmed by Walmart's actions or policies. Rather, the plaintiff's burden is to prove by a preponderance of the evidence that Walmart engaged in an overall class-wide practice of time shaving, denying or discouraging rest breaks or meal breaks, and requiring off-the-clock work by its hourly employees.
Let's talk about this case. How is this
Okay,
case
let's take a look at one of our theories under Iannuccino. At the end of the...
I want to know pragmatically. I mean, if we send this back to a judge, we're saying, Judge, you need to figure out a way to try this case, and I'm trying to figure out how this case would be tried.
If I might, in phase one, and I'm trying to answer your question, at the end of the trial, the jury would get a question, or the judge would decide, did FG&E's customers on an overall class-wide basis pay for a level of emergency preparedness which they did not receive? And if I might turn to your recent Claremont v. Gainsborough case, which is not that dissimilar. I think it's very similar, but there was one person involved. Now we have many. But if I might, at the end of the trial on that theory, I think
So phase one, did the customers pay for a level of emergency preparedness that they did not receive? Let's assume the answer is yes. Where do you go from there?
you go to phase two, damages, which is, you go to phase two, damages, which, again, which gets us back to the issue in phase two. We do not believe that, and you've said in Salvis that...
Where is causation in there?
In the damages part, right? You put causation in phase two, correct?
Well, if I might real quickly, and let me use this as an example on your Claremont case. So I think the special question would be, was FG&E's course of conduct in this case on an overall class-wide basis unfair? There might be another question, did FG&E's unfairness adversely affect the plaintiffs and putative class members on an overall class-wide basis? So I would tell you to take a look at Tyler v. Suffolk County, where what was involved there were unconstitutional conditions in the jail. And I guess the individual jail cells would be like the individual customers. It was the system affected everybody. To put it another way, all the prisoners were subjected to an unconstitutional system. Here we're saying all putative class members were subjected to an unlawful system, and the only issue is damages in phase two. And, you know, phase one is no small thing, but I believe, Judge Gantz, you said in the Olson case, if we can get yes answers in phase one, you know, did people pay for something they didn't get? Did FG&E act unfairly? If we can prove that in phase one, as you said in Olson, you know, creative ways, you know, will have to be found to deal with this. And if I might, real quickly, for example...
To do it real quickly, because your time is up again. Your time is up.
Yeah, thank you.
You want to summarize?
If you take a look at Judge Gertner's Payne case, she talks about if you can get past phase one, the court and the parties coming up with some type of a formula or whatever. I told you about Judge Gantz and Olson. If I might, the last thing, Judge Posner has done a lot of writing on class certification. He supports class certification. In his writings, he said, there's got to be a cohesiveness you talked about in Salvis. There is here, because we got lower court findings on systemic failures, course of conduct. If we can win on phase one, Judge Posner would say, then either the case should settle or the court system should come up with a way to compensate people. And if I just could finish, that's what you said in the Feeney case. Thank you, Your Honors.
Thank you. We'll take our morning recess.